I'm Lynn Marcus, and I'm the Director of Immigration Law Clinics here at the U of A James E. Rogers College of Law. On behalf of the directors of the Bacon Immigration Law and Policy Program, I'm delighted to welcome you to this talk on the future of asylum in Africa and beyond. And we are very lucky to have with us Professor Leah Dimorwimo of Nelson Mandela University in South Africa. She's here to share her information and insights with us. And we appreciate all of you students, all of you community members, people from other parts of the university, friends and colleagues of ours and of Professor Nidorwima, who have shown up today, whether you're here in person or on Zoom. So welcome everybody. And before we start, I always want to thank our incredibly hardworking and dedicated law clinic administrators, Rena Mendez and Caroline Taylor. They do all the behind the scenes stuff and also with the help of some student workers. We appreciate all of you. Yeah. Two quick preliminary notes first. We are recording this event to post to the website. So if you raise your hand to ask a question, you're agreeing to the use of your voice and image in this way. If you're not okay with that, then please write your question out and on a note card or a paper and wave it, and I'll come get it during the Q&A session. And as for the structure of the talk, I'm going to introduce our speaker, and we'll also join in at a couple points in the talk to provide a comparative perspective as to U.S. asylum laws and policies. And we'll end no later than 1 o'clock with the formal presentation so that we have at least 15 minutes for Q&A. And Immigration Law Students Association Leadership Board member Marshall Madison is monitoring the chat for questions. So we'll have those as well. Okay, so that's for the preliminaries. And now to introduce our speaker, Professor Leah Dimorwimo is visiting Fulbright scholar. She's an associate professor at the Faculty of Law at Nelson Mandela University in South Africa. Her undergraduate degree is from her country of origin, which is Tanzania. And she got her law degree in public international law from the Northwest University in South Africa, and she has an LLM in labor law from then Nelson Mandela University in South Africa. Professor Dimorwimo lectures and supervises undergraduate and postgraduate students in public law, labor law, and multidisciplinary studies. He teaches various subjects, and those include refugee law, private international law, public international law, constitutional law, and labor law. And her research interests include international human rights, international humanitarian law, and refugee law. Also the law of internally displaced people and interdisciplinary studies in Africa. There were more, but those are some of them. She has written a book called Post-Conflict Reconciliation and Transnational Justice, a case study of human rights violations in Burundi, and a book chapter on a related topic. She has also authored and co-authored 19 peer-reviewed articles, and just a few that I picked out the titles of: A Critical Analysis of the Proposed Law on the Employee's Right to Disconnect in Kenya, A Critique of the Efficacy of the Right to Shelter for Street Children in Kenya, and Reconfiguring the Right to Food Security in Post-COVID-19 Africa. Also, the impact of climate change on statelessness in the Southern African region. She's presented 38 papers at national and international levels and received the Nelson Mandela University Vice Chancellor Research of the Year Award in 2023. Funding freezes to the Fulbright program are upending the lives of visiting Fulbright scholars here and U.S. Fulbright scholars abroad at this moment. Professor Dimorwimo is slated to be here through September, October. We certainly hope that this upheaval will not disrupt that. our exchange with Professor DiMarimo is enriching has been enriching for many faculty and students here at the University of Arizona, and also for me personally. It has been a real pleasure getting to know her. She's not just bright, hardworking, and accomplished, but she's just a lovely person. And I've been
Yeah, hello everyone. Thank you so much, Professor Lynn Marcus. Really, I don't know what to express myself about you because you have chosen to adopt me as one of your family members. Thank you for that. Yeah, before I start my talk, I would like to thank the University of Arizona and James E. Rogers School of Law in particular, and the staff members of the School of Law, as well as the students, as well as the team in the law clinic. You are amazing. As well as the library team. I remember when I arrived here, one person asked me, "Do you have a cat card?" And I said, "What is cat card? What is that?" So the library team was so helpful until I got the cat card. So thank you for that. Special thanks to Professor Benjamin Lawrence, who is not here now, but he told me that he'll be late because he has got other engagement. You wouldn't have seen me here if it wasn't because of Professor Benjamin Lawrence. That was the only person I knew before I came to South Africa. But now I've got a village. I'm so honored.
Before you came here?
Yes. Yeah. Before I came here, I knew only Professor Benjamin Lawrence. And the one who is the reason for me to be here, because I met him in South Africa as a Fulbright scholar, and he did some presentation in my class on refugee law, focusing on what is happening in the United States. Also, I would like to thank other people. Thank you, the ISCASTAR team and Dr. Barbara. Thank you so much for also allowing me to participate in what you do for refugees and asylum seekers and immigrants and destitute people. Also, I would like to thank Professor Desiree, Pastor Desiree, for really helping me to settle here. Thank you so much. I really appreciate. And of course, with other professors who have invited me to go to their classes, like Professor Marcelo, Professor Amy Hudson. Thank you so much. So without wasting time and others, I would like also to acknowledge my university, especially the Faculty of Law at Nelson Mandela University. We are particularly the criminal and procedural law where I belong. Special thanks, and thanks to all people who are watching online, my family, my students as well, and other friends. So today in this talk, I'll be focusing on the protection of asylum seekers and refugees in South Africa and selected two countries of Tanzania and Malawi. I'm going to highlight on the imperfection of law and policies which to a larger extent, they do have impact on refugees and asylum seekers. In attempt to address the gaps which are found in immigration laws and policies. This study will look at the background of post-displacement around the world, in Africa particularly, and also to try to navigate around the question on whether the current existing legal framework withstands the growing pressure of political shift. In my discussion, I'll start with the framework, international, regional, and national legal framework. And also, I'll touch on the court interpretations of the refugee laws and policies. In doing so, I'll try to make an analysis of what is happening in South Africa and Tanzania and Malawi, and also try to touch on what Professor Rutinwa of University of Dar es Salaam, who has pointed out as the shutting door policies and opening door policies when it comes to asylum seeking. So I will try to okay. So basically, that's what I have already touched on the general introduction. This is the overview of our presentation. As I have highlighted what is going to happen. And when it comes to political realities, we have some sort of restrictions and a different judicial interpretation on the compliance of the principle of non-refoulement, which prohibits the refugee hosting states to deport the asylum seekers and refugees. Also, Prof. Lynn Marcus is going to jump in to try to share on the US experience, and then we make up the conclusion. So I want us to reflect on this statement from Tariq Ramadan, who says, your is not the refugee. Your enemy is the one who made him a refugee. I want all of us to try to think about that. Oh, thank you. I can see Prof. Benjamin, whom I mentioned earlier, is here with us. Thank you so much, Prof.
Sorry I'm late.
No problem. I've already told the audience. So when you see asylum seekers and refugees in your countries, you may think that, oh, why these people are here? But you need also to think what caused them to be here. I think that is a powerful message. And by the way, this quote is stated in the South African white paper of 2024, which was adopted last year, which is trying to limit the rights of asylum seekers and refugees, and including wanting South Africa to withdraw from being a state party to the refugee conventions, and especially withdraw from the aspect of non-refoulement or compliance with the principle of no-refoulement. So in my discussion, I'm going to, as I highlighted before, I'll be looking at South Africa, Tanzania, and Malawi here on the map. But I have also highlighted on what used to be called Zaire, which is now Democratic Republic of Congo. Why am I bringing in the Republic of Congo in my discussion is because you cannot talk about forced displacement in Africa without touching the issue of Democratic Republic of Congo. You might agree with me that here in the US, you do have refugees and asylum seekers from the DRC. Likewise, in South Africa and Tanzania and Malawi, there are also refugees and asylum seekers from the DRC. So these are the stats. These stats don't tell us the whole truth because these were the stats reported in the mid of 2024. But what is interesting is that after these figures, a lot of things have been happening. If we hear what is happening currently in the DRC and other African countries, as well as beyond South Africa, beyond Africa. I would like us to at least to pause a little bit and listen to this video.
So I don't think you need to click on that because he's got it, right? So if we minimize,
Oh, okay. Yeah,
Yeah.
thank you.
and if you want to start where she is,
Yeah. Yes.
where she is,
Yes, please.
it starts a little bit. She's just spoken a little bit on this newscast.
The Human Rights Chief has warned that the conflict in the Eastern Democratic Republic of Congo risks spreading and the worst violence may yet be to come. Volker Turk was speaking at an emergency session of the UN Human Rights Council in Geneva. Rwandan-backed M23 fighters took the city of Goma last week. There are reports of widespread human rights abuses, including sexual violence and the recruitment of child soldiers. Let's speak now to our Africa correspondent, Barbara Plett-Usher, who's in Nairobi. Barbara, hello to you. There have been hopes that the presidents of the respective countries, DRC and Rwanda, could get together and have talks that might lead to an end to this conflict. Is there any further development on that?
Yes, there is a special summit planned for tomorrow, Saturday. It's organized by two African regional groupings, the East African Community and the Southern African Community. And both leaders have said they will attend. So if they both go in person, that would be quite a moment because it's been very hard to get them around the same table in the past months. But we're not clear whether the Congolese leader will attend in person or whether he'll attend virtually. And there have already been two emergency summits, one by the East African Community and one by the Southern African one. And now they're bringing their forces together to again try to address this conflict because the concern is growing that it is going to escalate. And there is a concern that it escalates beyond the borders of the Democratic Republic of Congo, not to mention the great damage it has already done, the people who've been killed, the interruption to services, the humanitarian crisis. So there is pressure from the concerns of the region. Also, you heard that you mentioned the UN official there at the Human Rights Council, the UN Secretary General. They've all got this same warning that things could get much worse. Whether that leads to some kind of resolution seems to me unlikely, given the dynamics, but maybe the hope is that there could be a ceasefire and the talks could continue.
On the substance that the two leaders might get into, whether they attend in person or virtually, I mean, what would be the starting point, do you think, for those discussions in terms of trying to actually at least reach a ceasefire?
Yeah, that's a good question because they're very far apart. So the Rwandans
Okay, we didn't want to finish the whole thing because of the interest of time. This video clip or YouTube video clip was published at the beginning of the year. Okay, that's where they are when the armed conflicts were still going on, and they are still going on as we speak right now. And the number of the deaths which were reported by that time were 3,000 people killed. But as we speak today, the number has gone up to 7,000, between 7,000 and 9,000 today. And millions of people have been forced to leave their places of habitual residence, and they have ran away and seek refuge in other countries like the neighboring countries of Tanzania, Burundi, Rwanda. I'm not sure whether they go there. I'm not sure. I have no clue. But capturing on what we heard, all of us, really, we can acknowledge that there is a crisis. Yeah, I'm going to skip these trends, but as you can see, from 2017 to last year, the number of forced displacement keeps on growing in Africa. Okay, and today in our talk, we are going to focus more on external displacement, because we don't want to talk about internal displacement. That is a talk of another day. Okay, so going now to the legal framework, we have the International Convention, the 1951 Refugee Convention, and its protocol of 1967, which define who a refugee is, as well as the prohibition of expelling refugees and asylum seekers under Article 33. Again, there are other conventions, like the Convention Against Torture, which also under Article 3 reinforce the same principle of compliance with law reform. In Africa, we have what we call Organization of African Unity, which is OAU. Now OAU has changed to African Union. Refugee Convention, which also state the same thing and also define who a refugee is. In our talk, we'll be referring to both refugees and asylum seekers, because these are two different concepts. Refugees are those ones who have been formally recognized in the context of our Refugees Act of 1998 in South Africa, as well as the same Refugees Act of 1998 of Tanzania, and Refugees Act of 1989 of Malawi. The 1951 Refugee Convention defines who a refugee is. But in the African context, of course, you see the grounds for persecution like race, religion, nationality, member of a particular social group, and so on. But the beauty of the OAU Convention is kind of trying to broaden the definition of refugee, because it includes the grounds like external aggression, occupation, foreign domination, like what is currently happening in the DRC, or the events seriously disturbing the public order, either part or a whole of the country. So what is happening in the DRC mostly is the Eastern DRC, Congo, which is suffering. But it doesn't really mean that the whole DRC is safe, because if one part of the country has got issues, of course you can expect that it's going to spread across the country. So if we compare the definition given under 1951 Convention, it provides a kind of narrow view, because it is kind of in the individualized definition of refugee that focuses on persecution based on the mentioned grounds. And also, we must also remember when this convention was adopted, it was after the World Wars, and mostly was trying to protect the people who were being persecuted in Europe. But later, with the protocol, it expanded a little bit the definition to include other refugees and asylum seekers from other places. But yet, the definition under 1951 Convention is still narrow if you compare with the 1969 OAU Convention, because the 1969 OAU Convention adopts a kind of broader view, because it takes into consideration the historical background, like the colonialism, apartheid, which happened in Africa. And also, it has a kind of more inclusive and humanitarian approach. I'm going to talk about this, especially when I'll be dealing with Tanzania, because Tanzania is one of the African countries which, in a way, tried to embrace what is provided for in terms of the OAU Refugee Convention, although even Tanzania now is shifting, is no longer doing what Tanzania used to do before. Yeah, so I don't want to repeat this because I have already touched on the principle of no refoulement. So let us start now with South Africa, where I'm coming from. Okay. Yes, originally I'm from Tanzania since 2000. I've been living there. I'm a permanent resident. I'm not a citizen yet because there are a lot of things to talk about, but I don't want to talk about that. South Africa was colonized by the Dutch and the British since 1960 and since 1652 to 1994. Okay, you take in mind that time period. And in 1994, South Africa became a constitutional democratic country. But during apartheid and colonialism, only whites from Europe and from the then colonies of Mozambique, Rhodesia, and Namibia would be recognized as refugees, but not blacks. Yes, there were some black immigrants in South Africa by then, but they were not recognized as refugees. They would be allowed to come to South Africa as migrant laborers to work in the mines. It was until the constitutional democracy of 1994, through the enactment of the Refugee Act of 1998, which came into being after South Africa became a state party to the conventions, refugee conventions, which I have highlighted before. In South Africa, after the enactment of Refugees Act, of course, the definition of refugee is there, and refugees are also recognized, especially Black refugees, and it provides for the protection of asylum seekers and refugees, and has been viewed as one of the progressive pieces of legislation in South Africa. And it entitles refugees with constitutional rights in terms of Section 27, except two rights: voting. Refugees are not allowed to vote, and they are not entitled to get or to get what we call RDP houses. RDP houses are governmental programs which give the South African citizens, especially those who were disadvantaged during colonial and apartheid rules, as a way of remedying the situation, but refugees are excluded. And in South Africa, they don't have refugee camps. They have adopted what we call urban refugee policy. Refugees will be, if they are recognized, they can integrate into the society, and they must know how to survive by themselves. Okay, so long they have got those papers. So South Africa has hosted a lot of refugees from Rwanda, from Burundi, from DRC, from Zimbabwe, from Angola, from Somalia, Ethiopia, Pakistan, and the list goes on. And what is interesting is that Refugees Act of 1998 has undergone several amendments. And these amendments have now shifted away from the original focus, which are imposing some strict immigration controls and also limiting asylum applications. And because there are some arguments or some views that refugees need to be limited because of security concern. Okay, thank you. So time is not on our side. Yeah. Then we go to Tanzania, colonized by German and British, and also Tanzania introduced restrictive immigration laws, and also during 1961 to 1980s, Tanzania hosted refugees from Rwanda, Burundi, Uganda, but also South Africa, Mozambique, Angola, and Zimbabwe, by that time when it was still under British colonial rule. During this time, South Africa had what you call open door policy, would welcome refugees, and Tanzania has what we call encampment policy, where refugees are put in designated areas as in the refugee camps. But also when we talk about Tanzania, how it has hosted refugees, especially refugees from Burundi and Rwanda, there are different case laws. The ones who ran away in 1972, they were given group naturalization. That's what I was talking about. As well as the Rwandese refugees who ran away in 1959 to 1960s, they were given also group naturalization. Although there are some literature which suggests that one scholar, Mwapinga, has also questioned the naturalization of Burundian refugees versus Rwandese refugees, because in his view, he said that Rwandese refugees have been given or have been integrated fully compared to the Burundian refugees. Malawi also colonized by British, but also some Malawians migrated to South Africa to work in the mines, as I have highlighted, has also hosted refugees from different countries like Burundi, and also Malawi is seen as a transit to other countries, especially South Africa. But since 2017 has adopted stringent laws and policies. So now I'm going to hand over to Prof. Lynn Marcos to share with us a little bit about the US. Over to you, Prof.
Before I did that, I noticed this. Did you want to say anything about that?
Oh, okay. Thank you, Prof. I was just rushing because of the time. In Tanzania, Refugee Act was repealed after the influx of more refugees from Burundi, Rwanda, and DRC. Why? As I indicated to you, refugees in Tanzania, they can be categorized into different case loads. There are those of 1972 case load. They are the ones who were given a naturalization. But there are others who fled in 1994 after the assassination of the Hutu president in Burundi. Those were not given naturalization. As well as Rwandese who fled after the 1994 genocide. They were not given naturalization. Instead, they were sent back. They were deported, a majority number of them, whereas those countries by that time were still volatile. Okay. Thank you, Prof.
Yes. And I, sort of like slow down, speed up. I just want to make sure that we covers all the areas that you sketched out for us. So the United States, you can see the comparison here that the United States adopted the same 1951 Refugee Act when we signed on to the 1967 protocol. We signed on to the 1967 protocol in 1968. And then it was in 1980 that we adopted our Refugee Act. So that was 9 years before, was it Malawi? And 18 years before the other two countries. So in the non-refoulement provision was just put straight into domestic law, and it's still there. The refugee definition was taken straight out of these conventions, and that's what it still is. And then in 1994, the United States signed on to the Torture Convention and then implemented it through domestic legislation and then regulations in 1998. And the relevant aspect of that is the same non-refoulement provision. It's a little different because you don't have to be a refugee, you have to be a person facing torture, which is defined a little differently. So the 1980 Refugee Act has two main parts. It's got this detailed annual process for admitting overseas refugees, which is not required by the convention. It's something that the United States decided to do, was people who meet the definition of a refugee abroad, people generally who are in overseas refugee camps. There have been over 3 million overseas refugee admissions since it started. And then the second part is the right to apply for asylum at the border of the United States or within the United States. And there have been approximately 1 million grants since 1990, but the only statistics I was able to quickly find were since 1990. So there's 10 years before that. I don't know what the numbers were, but it's less than the refugees from overseas. So the refugee of 1980 there have been restricting legislation since then. In 1996, there was Congress imposed a 1 year from arrival filing deadline on asylum. That doesn't suspend the non-refoulement provision, which means you can apply for asylum, which is a broader form of protection that can lead to full integration with full rights. Non-refoulement is just the bare minimum. It also created a screening process for the first time and an expedited removal process whereby a person could be removed without seeing an immigration judge, without a full adjudication, but just a screening interview, usually by an asylum officer. And basically to see if the person has a credible fear, if they can show credible fear, which is basically enough of a chance that they could make out, that they could show they met the refugee definition. Then after 9/11, there was the USA Patriot Act, or sort of because of 9/11 of 2001, that expanded security bars to include things like material support to a terrorist group. And it sounds like that wouldn't affect anybody that would care about, but in fact, many clients that we've seen meet the definition of terrorism because it's so broad, including extortion, where you either pay or die, or any kind of cooking a meal for the group that's engaged in terrorist activity. And also increased deference given to judges to find people not credible based on their demeanor, based on any type of inconsistencies, and to require corroboration when the judges find that corroboration would be reasonable. Yeah, that's all I had for now. So just to show you, that's been the progression of the legal protection of the U.S. And you notice this does not include the broader protection of the OAU. It does not include people that you saw in the video necessarily, who are fleeing from a mass destruction, civil war situation, etc. You have to show individual targeting with much narrower.
Thank you very much. Now let us move to how courts have been trying to interpret the refugee conventions and principles. South Africa, there is a well-known case called Ruta versus Minister of Home Affairs. In this case, was a Rwandese refugee who entered South Africa illegally, and he managed to stay in the country for about 15 or 16 months without being noticed. However, he was in contravention of traffic rules. That's when he was caught. And when he was caught, they found out that he was an illegal immigrant. And he faced deportation, but he challenged that. And the Constitutional Court decided that South Africa was under obligation to uphold the principle of no refoulement. So, to be honest with you, South Africa has been doing well in terms of court litigations. And that's why this case was decided, which was decided in 2018. It was approved in other cases in 2021, the Abore case, as well as Ashebo case, and the last year's one, the Scalabrini Center versus Minister of Home Affairs, because the Ruta case decided that the principle of no refoulement applies for both de facto and de jure refugees, meaning those refugees who have been formally recognized, and those who are not formally recognized. In Tanzania, really no much litigations, but there are two cases I picked out, and these are district magistrate courts decision, whereby the principle of non-refoulement was being touched a bit, but in the Republic versus Ali, Gilbert, and others, a majority number of the applicants were deported to Burundi because there was no compliance with the principle of non-refoulement. In Republic versus Ilola, also this case demonstrated how there was not a proper coordination because the asylum seekers were arrested for being illegal in terms of Immigration Act, and they faced deportation. And then instead of being deported, they were arrested for almost 1 year. And then after 1 year, the authorities just realized that, okay, the procedures were not followed. So they sent them to the United UNHCR for refugee or asylum determination. You can imagine someone who had been in custody for over 10 months. So then in Malawi, the same thing, no many court litigations like South Africa, but there are these, the case of Aden Abihaji. This case involved refugees from Somalia who faced deportation for being found illegal in Malawi. Here, it was a high court decision, and the court acknowledged that Malawi was under an obligation to comply with the principle of non-refoulement, or not to deport the Aden and the other applicants. But interestingly, in another case of Kaminingi, Jones, and others versus the Refugee Committee, which was a magistrate court decision, these refugees were from Mozambique, who were accused of violating or causing insecurity in the country. So the principle of non-refoulement was not accepted in this case. So these few cases highlight that there have been many litigations in South Africa from the High Court, the Supreme Court of Appeal, as well as the Constitutional Court, relating to the protection of refugees and asylum seekers. But as we can see, in Tanzania, we don't have a lot of court litigations. Okay.
There have been in the United States, I think just 4 Supreme Court decisions. Well, no, there's been at least 5 Supreme Court decisions regarding asylum. The first one was a restrictive one, and actually all others since, except Cardoso Fonseca. Between Stevic and Cardoso Fonseca, it was established that non-refoulement is mandatory for refugees, but only those who can show more than a 50% chance of this individualized persecution. And I'm interested in hearing a comparison on that. But the next decision was that there's people who, that the refugee definition is broader than that and includes, if you can show at least as low as a 10% chance of persecution. I've just confused the heck out of you because it's confusing, but what it means is that you can be a refugee because you have a well-founded fear of persecution 1 in 10 people of your characteristics will be harmed in a very severe way or killed. But you can still be deported from the United States unless you meet this higher burden because of the way that the non-refoulement provision is worded. The court, or the U.S. Supreme Court, looked very narrowly. This would be, your life or liberty would be threatened language. And so I don't think in anywhere else in the world I know of that you have this dissecting between who's a refugee and who's entitled to non-refoulement. If you're a refugee, you're entitled not to non-refoulement, but not in the United States. There was also INS versus Elias Zacharias, a person who's targeted for severe harm for strategic reasons. In this case, he was claiming that both the army and the guerrillas were trying to recruit him, and one or the other would kill him if he didn't join. And even if that were true, he would not meet the definition of a refugee under US law because it's not on account of one of those 5 characteristics, according to the court, that he is going to lose his life or liberty. So he wouldn't be a refugee. Going to skip sail in the interest of time, but it has to do with what the United States can do out of territorial waters, which is to say the convention doesn't restrict US actions according to the court. And then just to highlight some recent flip-floppy decisions that sort of show you the power of the administration to change interpretation. Domestic violence was recognized in certain circumstances if the country is unable or unwilling to control the persecutor as a basis for asylum. In 2014, a lot of women and children were released from custody that August. But then during the first Trump administration, it was decided that that is not a basis for asylum. And then in the Biden administration, it decided that it was. That is currently the state. Guess what we expect? Persecution based on family membership. Like if you're persecuted because your father is a prominent whatever, right? Or because somebody wants to harm your father, then that was a basis. Then under the Trump administration, the Attorney General revoked that, and then the Biden administration put that back in place. So you see, when you have Attorney General decision, that's the Justice Department, that's the executive reaching in and changing the interpretations.
Okay, so from what we have already discussed, you can see that South Africa, Tanzania, and Malawi have undergone 3 phases when it comes to refugees or immigration laws and policies. Colonial restrictions and post-independence humanitarian commitment, and more recently, going back to stricter laws and policies. But at the same time, these countries remain key hosts for refugees, as I have indicated before. But while the policies also emphasize on regulation and repatriation of refugees. So it's a kind of contradiction. You have refugees, but at the same time, you are telling them, oh, you must go back to your country. Where they know that in their respective countries, there is no peace. If we can cite the case of DRC. And all of them have adopted, as I indicated, stringent refugee laws and policies trying to limit asylum seeking, as well as basic human rights like right to work or healthcare services or education, and encourage more repatriation that can include deportation. So most of them, like in South Africa, you find people have been on asylum seekers visa for more than 20 years, which means these asylum seekers permits, they cannot allow you, if you are an employer, you cannot take that person as your employee, because has no kind of legal document which can allow him or her or them to work. This goes to the even enrollment at schools, the same thing. So there have been a kind of shift from humanitarian approach in terms of the OAU Convention of what they used to have before 1990s, the open door policy. And now they are favoring what Prof. Rutinwa calls cross-door policy. And they have failed to uphold the principle of no refoulement. Of course, there are reasons which have been put forward, but I'll touch on that later. But we can also acknowledge that many African countries are deeply fragile, politically, socially, and economically. And if we can cite examples from the what is happening in the DRC, in Ethiopia, Sudan, Mozambique, there are some armed conflicts which have been happening in Mozambique, as well as Burkina Faso, Mali, Niger, Kenya. Last year, you might have heard of the Gen Z movement. It really shook the country. I don't know what is the current position. Many African countries are still grappling with armed conflicts and coup d'etats. And there are some issues of internal power struggles and, of course, chronic economic challenges. Also, inadequate border control, corruption, incompetence of refugee determination and immigration officials, as well as limited access to legal representation. And I think in countries like Tanzania and Malawi, that's why they don't have many court litigations. In South Africa, is a way better because of the economic kind of way better than Tanzania and Malawi. Although even in Tanzania, in South Africa, lawyers who deal with refugee and immigration cases, they are not state funded. It's just maybe they get funding from NGO. And only in South Africa, we do have, like, in terms of even teaching refugee law, out of 26 universities in South Africa, only 4 universities are teaching refugee law, including my university and University of Cape Town and Wits, there is another one. So these countries, sometimes they prefer short-term solution than long-term solutions. For example, they give them the short permits, which can allow them to be there, or they encourage what we call third country resettlement, which in my humble view, I think Prof, you will agree with me, is a kind of form refoulement, because you tell them, okay, we can't host you here, but go to the state, go to Canada, go to Australia, whereas yourself, you are unable to host them. Then they don't provide the durable solution. And also the definition of refugees in terms of both conventions, whether it's the 1951, even the OAU convention, which is kind of broader, doesn't cover all the grounds. Like, for example, climate change is nowhere to be seen in these conventions. Also, there are other grounds for persecution, like asylum seekers who may have, like, let's say, claims based on their sexual orientation. These legal frameworks do not cover that. And also there is a financial constraint. Over to you, Prof.
Yes. So this is going to be super quick, as because you are familiar from the news from a lot of restrictions that have been happening in the United States. There have been surges, especially during the last administration, in migrant arrivals. Lots of political polarization, and there is here as well no provision for free counsel. The Biden administration did make some exceptions for children that are being undone. And then during the first administration, what they called the death to asylum regulations, which the court did enjoin, and the dismantling of the overseas refugee program and admissions under the of institutions, admissions plummeted. The Biden and Obama administrations have tried to play both the humanitarian side and the restriction side. And so there have been the humanitarian programs, which the Trump administration has now ended. And, just making access to the process harder. At this point, access at the border does not exist as the border has been frozen. And we're seeing chain refoulement, including a client that the clinic represented in a bond hearing unsuccessfully, where the Florence Immigrant Refugee Project then won asylum, a gay man from Guatemala, who was then immediately, as soon as we celebrated, deported to Mexico, which turned him around, deported him to Guatemala. You've heard the same thing in the news with the guy from El Salvador who is in prison right now in Venezuela.
Okay. So the reasons for adopting closed-door policies, most of the governments say, okay, it's because of security concerns, like what is happening in Africa, the terrorist attacks of Al-Shabaab and Boko Haram, like in the Sahel region, in countries like Nigeria, Niger, Mali, Burkina Faso, and so on. Also, there is a kind of lack of refugee burdening sharing at the regional and international levels. Because when I chose Tanzania and Malawi and South Africa, yes, these countries have been hosting refugees. And for Tanzania, to be honest with you, it has been hard to host refugees. I think it's because economically is not like South Africa, for example. I don't want to compare with the US because the US is more advanced. And because of that, they say, no, why these countries are producing refugees, but now they are bringing to us to become our burdens. Now, we don't want that because there is a lack of shared burden. Also, there is xenophobia, indirect one or direct one. Direct one in South African case, immigrants have been set alight. I think you might have heard that for many instances, and is not something good for the country. Yes, some views put forward because they say during the democratic campaigns, for example, you find even political figures, they promote xenophobia in order to secure their political cards. In the South African context, for example, I can give you two politicians, Malema of Economic freedom. He embraces foreigners in a way, but that has costed him his down. But if I compare with his colleague, Dlamini, who came up with the idea of Dudula. Dudula means pushback, whereby he started a kind of movement which where they could go door to door. They ask whether if they know that you are a foreigner, they don't care whether you have got legal documents or not. You are a foreigner, you must go. Pushback, meaning Dudula. But to your surprise, the same movement was registered as a political party. So I don't know why. I don't want to engage in that. Yeah. So, okay, yeah. So we have got a magnitude of refugee problem, and sometimes the local communities feel that they are overwhelmed because of the presence of refugees and asylum seekers. And for countries which have got encampment policies like Tanzania and Malawi, there are issues of ecological or degradation which have affected the environment. They say the presence of refugees, they are causing ecological related issues. Also, they associate refugees and asylum seekers with committing crimes. And also, another thing is restrictive refugee policies in the Western world. If they hear Europe is restricting refugees, then they say, okay, in Africa, why do we remain hosting refugees? By the way, in Europe, they are limiting them. In the US, they are limiting them. In wherever other countries, they are limiting. So let us follow the suit. And most of them, they follow what is being done in their colonial countries. Also, another reason they say hosting refugee states, if they keep on hosting refugees, they are going to damage their inter-state relations. This was done by Tanzania, where Tanzania didn't want to damage the relationship with Burundi, with Rwanda and DRC because they want to maintain good relationship. While at the same time, the same countries are still volatile and they are still producing refugees. Thank you. Okay, so conclusion, there is a global crisis. Also, in African context, they had this African Union agenda where the heads of state came together and said, this is the Africa we want, Africa with no war, a peaceful Africa. But what is happening on the ground is contradiction. So, in conclusion, we can say that we would like to recommend, I have discussed with Lynn Marcus, that the conclusions are more or less the same for the US as well as Africa. That there is a need to minimize over-regularization of the asylum processes. Also to reform the asylum system, like strengthening the enforcement and monitoring mechanisms, also expanding the refugee definition. Also, upholding no refoulement remains important, especially for both countries, South Africa, Tanzania, Malawi, and the US, in order to fulfill their constitutional and international obligations. There is a need to find a balance between national security and economic concern, but at the same time, humanitarian responsibility. And also foster cultural dialogue and social cohesion. As we are here today, this is the beginning of conversation. I think when it comes to issues of refugees and asylum seekers, it is not a one-man show. I think it's a highlight to stop working in silos. We need to work together, whether academics, lawyers, religious leaders, a non-governmental organization is our problem. We cannot just wait for the executives to give us solutions. As I highlighted before, in the US, at least, it is much better. You've got federal, state, and state government support when it comes to financial support. But in South Africa, Tanzania, Malawi, which are developing countries, they always rely on the international and humanitarian assistance. If the international organizations say we don't have funding, then nothing they can do. Also, there is a need to critically analyze the strengths and weaknesses of asylum seeking in order to identify the gaps and to see where improvement can be done. Also, to really address the root cause of forced migration, collaborating among all stakeholders. And also financial support, because you would agree with me that immigration and refugee lawyers, legal practitioners like Prof. Lynn, I promise you, these lawyers go through a lot when they listen to asylum and refugee related cases. They are emotionally draining. Sometimes I really feel like, oh, I think for them, they need even more support. I'm not minimizing that other fields of law are not equally important, but when it comes to immigration and refugee legal practitioners, they need more support. Technical support as well as financial support. Thank you for listening.
Thank you so much. I want to respect the time of those we have not, it's just my fault entirely, provided for our comments to allow a time for Q&A. So for those who need to leave at this point, please feel absolutely free to do so. And those who can still stay will have a bit of Q&A until they kick us out of the room. Do we know if there's a class at 1:30?
There is some time.
At 1:30? So I think that we should have at least 7 minutes of Q&A for anyone who has questions. Are there questions
Thank you so much.
in the room?
I don't remember.
Okay.
I think we're okay.
If anyone, while people are leaving, has a burning desire to ask a question, or in the chat. Great. So Madison, how would you feel about coming up to the mic and reading questions? I told her about that.
Okay, the first question comes from Professor Marcelo Rodriguez. He asks, what is the role of sub-regional organizations in Africa, such as ECOWAS, or East African Community, or SADC, when it comes to refugees, as they seem closer to these communities on the ground? Should they provide an alternative route when larger organizations such as the African Union or international ones are losing influence and are perceived sometimes as paralyzed? That's for you.
Thank you so much for the question. Thank you, Professor Marcelo, for the question. Yes, there are some regions of ECOWAS or East African Community or SADC. They have a major role to play when it comes to addressing the issues of asylum seekers and refugees. For example, the DRC with Congo, which we are talking about, is part of these communities, but yet the these sub-regions are kind of silent when it comes to addressing the issues of post migration. So they when it comes to the alternative route, when larger organizations like African Union and international ones are losing influence, I'm not sure whether they can do much. Because remember, when these organizations or these sub-regions were formed, also it's like they report to their superiors. So like the ECOWAS, the East African Community, the SADC, they are part of the African Union. But I totally agree with you that if they were to step up and tell the AU, the AU or the UN that you guys, you are failing us, is better for us to take on. Maybe that could be a better solution.
Okay, thank you very much. Do you want to take the question?
Yes, yeah.
So this one should be quick, I think. Thank you for the information. I learned a lot. Yeah. When asylum seekers enter South Africa, is there a legal organized vetting process for them after entering or at the border?
Okay, so the question is that when asylum seekers enter South Africa, is there a legal or a vetting type of process at the border?
Yes, in terms of Refugees Act of 1998, the one which I highlighted, although it has undergone different amendments, yes, there are processes to be followed. Once an asylum seeker has entered South Africa, has to report to the authorities for asylum determination. Then before it used to be like 30 days, but now, according to the new amendments, they've been reduced to 10. And also, where they report before, we used to have many offices, but now the offices were reduced. So you can imagine someone enters from the border of Zimbabwe, for example, and being required to go to report, let's say, in Pretoria or Cape Town or Durban or Port Elizabeth, which is Gqeberha, is not really practically possible. Yeah, there is refugee reception offices where the asylum seekers can go to. And then once their asylum will be started, they are going to be screened through the interviews. And if they are successful, they'll be given asylum visa. It used to be valid for 3 months, which is could be renewed, and then a letter was extended to 6 months. But sometimes, that's when I said, there are asylum seekers who have been on the asylum seeker permit over 20 years. Okay. Then from that, those are called Section 22 visas. Then there are Section 24 visas, where now an asylum seeker will be formally recognized as a refugee. It used to be 2 years, but the law was amended to extend to 4 years. Until now, it's still 4 years. But the problem is, once those visas are expired, to get them renewed is a problem. In many cases, some refugees who had been granted with, let's say, refugee status visa in terms of Section 24 of the Refugees Act will be taken back to asylum seekers, which is so complicated, meaning those are kind of indirect xenophobia in a way, because here you are trying to limit them to integrate in the society, and you want them indirectly, you are forcing them to go back. Thank you.
There was one more chat question. Let's see if we're gonna have the time for it. So, okay, so please explain the Refugee Act repeal and the consequences of who gets naturalization and the consequences of integration. Is the policy politically motivated? How? Okay, this is from Dr. Beatrice Russell of California State University in Sacramento. So if we need to be out of the room by, we're not sure?
She thinks we're okay.
Okay. Okay.
One
so
more
we're gonna
question.
take it.
Okay. Thank you so much, Dr. Beatrice from California State University. Yeah, once the Refugees Act is repealed, there are consequences. Let's say in South Africa, as I indicated in the previous response, asylum seeking will be compromised. As you heard, there are situations whereby they can be taken back. I mean, the asylum seekers or refugees who have been recognized can be taken back to asylum seeker visa. But of course, the Refugees Act provides for naturalization, and once before the amendments, especially the recent amendments, once a refugee has been staying in the country for 5 years, would be qualifying to apply for naturalization. And then that will be declared as a refugee indefinitely, then will be dealt with under the Immigration Act, whereby he will be recognized as a permanent resident, and then after other 5 years would qualify to apply for citizenship. Okay. But with the recent amendments, they have changed from 5 years to 10 years. Okay. Yeah. So I don't know whether I managed to answer your question, Beatrice, Dr. Beatrice. Then we can take other questions. Yes, yes, there is a question.
Yes, thank you very much for that very informative topic. That's from Burundi. And Burundi is a country neighboring the countries she is concerned with. I'm very happy to hear about the case in Tanzania. Maybe I was born a refugee in Tanzania. And until now, I'm still a perennial refugee.
Oh,
And Tanzania is a country that hosted my family when I was born, and I was born in Tanzania as a refugee. And we have to recognize the fact that Tanzania is, compared to the other countries, observing a relative stability. That's why it is receiving refugees from across the region. But maybe there is a funny fact I want to mention, maybe if I can pose a question. When you have to look at it, you realize that the great region that she's talking about is like Burundi, the country of my origin, is having refugees from, for example, DRC, Congo. But funny enough, Congo is having Burundi refugees. So there is this embarrassing question: what is the relationship between stability, peace, and refugees? Where does, and that's what the question is, where is the ideal place for a refugee? Is it a place of safety, or is it the immediate place, whether safe or not? That's the big question I'm having.
okay.
So Zoom, I don't know if it picks up anything, but our question comes from Odas from Burundi. He was born in Tanzania with his family, where his family was being hosted as refugees. And Tanzania has been a country of relative stability. But you have places like Burundi that are hosting refugees from the Congo, whereas the Congo is also hosting refugees from Burundi. And the question was, where is the ideal place for a refugee? Is it sort of like the immediate place that they flee to, or some other place? And I don't know that I really understand the question, because ideally the ideal place is the best place for safety and security for you and your family, right? But so I don't know if you have a different comment.
Okay, maybe what I don't know whether I understood the question correctly, but what I can respond to your question is, Tanzania is a country which is relatively stable over many years. And that's why it has hosted a significant number of refugees from all over, including actually in 2023, I was told, even Ukrainian sought asylum in Tanzania. So a place of refuge for refugees in the Tanzanian context, let's say, take an example of 1972 refugees from Burundi, who were given about 360,000 refugees were given group naturalization. And to be honest with you, we need to commend Tanzania for that. Given the fact that Tanzania economically is also not stable, Tanzania has got her own challenges. So by granting that group naturalization, in a way, it was a kind of responding to the refugee crisis in order to find durable solution to refugee crisis. But it's only Tanzania which did that. I'm not aware of any other country in Africa which has done that. Yes, Uganda, I heard about that, but it's not like what Tanzania did. Yes, there's still a few hiccups. I think I did point out in my presentation that one scholar, Mapinga, has highlighted this disparity between treatment of naturalized Burundian refugees and Rwandese refugees, but still is something which must be commended for that in order to find a durable solution. I'm not sure whether US has something like that. In South Africa, there was a kind of giving special permits to Zimbabweans and Angola and the refugees from Angola, but that was not comparable to what Tanzania did.
And what the United States has that's comparable is, I don't know if it's comparable, but is temporary protected status, which is en masse protection for 12 to 18 months that is designated by Department of Secretary of State, Department of Homeland Security, and I think can be designated by Congress for groups of people, and that would be not necessarily based on the refugee definition, but natural disaster, disorder, etc. However, as I'm sure you know, the current administration is seeking to eliminate temporary protected status, which now applies to millions of people, but that is and what may be tied up in the courts because of arguments that it's not being done in a legal fashion. We need to end. I want to thank all of you who have stayed this long. We don't have time for more questions. I'm so sorry for the questions we didn't get to.
But maybe they can still engage with us. I'm still around. Whoever wants to engage with us, yes, we can still engage.
Okay.
There was an